Okay. Before I call the case, I did get a notice as I was trying to get on YouTube. There was a notification that my internet connection's unstable. That's happened once before, and what happened is I lost my voice at some point in the hearing. If this happens, or just kind of give me a signal with your hand, something to indicate there's something wrong. I've checked on that before. I don't know what's really going on. Anyway, let me call the case for the record. This is cause number 1154. This is the estate of Edward Chris Smith. Before we proceed, could I have each lawyer identify themselves for the record?
Yes, good afternoon, Judge Orlando Garcia, here on behalf of the plaintiff, Samantha Smith.
Amanda Torres here on behalf of the independent executor, Joseph Richard Rod, or Rick Rod.
Okay, one other clarification, is Ms. Morales? Ms. Sonia Morales, or?
Yes,
you-
Kathy Morales, I'm the deputy clerk.
Okay, Ms. Kathy,
Yes.
yeah, good afternoon.
Good afternoon, Judge.
I had promised the parties in this case that I would check back with Mrs. Sonia Morales
Okay,
about whether you all had planned to go to trial on the 28th of September, or July or August as your first trial back. And I did call on that day or the Monday afterwards to see if that had actually gone through successfully. I wasn't able to get a hold of Mrs. Morales, but do you know if you've had that jury trial or was it canceled?
we didn't have a jury trial, no, Judge.
Okay, so it's still.
We can't hear you. You're cutting off and on, Judge.
Okay. That's
Now I
fine.
can hear you.
Okay. All right, then I'm not sure who should go first. Is there consensus on either side here?
Well, are you talking about, Judge, are you referring to the motion that's set for today?
Yes, the motion to exclude plaintiff's late designated witness.
Right. I have not conferred with Mr. Garcia about it. It's our motion to exclude him. I'd be happy to go first.
Mr. Garcia, do you have any objection or response?
No, I don't have an objection. It's
Okay,
Ms. Torres's motion.
all right, Ms. Torres, go ahead.
Thank you, Your Honor. First of all, I believe the court has set the application or the motion to exclude the late designated witness, which is Clay Hoblet. I did receive an order from the court ordering his deposition to occur in 60 days of that last order, which I believe was in September 3rd or 4th. And so I have not yet scheduled his deposition pending outcome of this hearing. So no matter what the outcome is, I just want to put that on your radar, Judge, that at some point, if you do allow him in, we will need to extend that deadline a little bit. So, Your Honor, we're trying to exclude Mr. Hoblet from testifying as a late designated witness. We have filed with the court a motion, and which I'm sure the court has now read, but essentially we are past the discovery deadline, and these plaintiffs, every time we hack down their legal theory, they find a new witness. So now they found several witnesses. The court allowed the depositions of Mr. Sugarick, his wife, and Bill Barfield. We did depose Mr. Sugarick and Bill Barfield pursuant to the court's order and agreement of the parties. After Mr. Sugarick's deposition, or during his deposition, he testified that he had consulted with a lawyer named Clay Hoblet about whether or not he should get involved in this lawsuit. And then after that deposition, but before we could schedule Mrs. Sugarick's deposition, the plaintiffs designated Mr. Hoblet as a witness and counsel for Ms. Sugarick. So the court has ruled on whether or not he should be allowed to serve as counsel and has ordered his depositions, as I mentioned earlier. but now we have this remaining question of whether he should be excluded or not as a fact witness. We believe the discovery deadline closed, and we believe that it is closed. The court has not yet reset this hearing and did not open any other deadlines. So there is no trial setting. The discovery period was opened only to allow us to depose the 3 prior late designated witnesses, Bill Barfield and the Mr. and Mrs. Sugarick. It was not opened in general. No other deadlines were reset. The trial date has been canceled, but there is no set trial date as of today. And we believe that the plaintiff, under the rule 193.6, cannot show good cause for failing to supplement this newly late designated witness on time. And he has, or she has, the burden of establishing good cause or lack of unfair surprise and unfair prejudice. Now, the response by the plaintiffs is, well, there's no way we could have known about Mr. Hoblet because he didn't come up until the deposition testimony of our last late designated witness, Mr. Sugarick. And the good cause exception permits the court to excuse untimely disclosures only where there is difficult or impossible circumstances which interfere with the discovery process. The inadvertence of counsel, lack of surprise, and the uniqueness of this evidence does not constitute good cause. So when this court allowed the last depositions to occur, May 2020, I believe at this point, Mr. Sugarick had already talked to Mr. Garcia. In his testimony, he says that he had conferred with him sometime in February, but he wasn't designated until after the deposition. So once he was deposed and said, oh, I've got my lawyer, I talked to my lawyer, he also said, I talked to my brother and my wife. The wife is on the list, the lawyer is on the list, the brother is not on the list. What's interesting about that is the lawyer, he talked to his lawyer, Clay Hoblet, and to and to his brother 2 years after the alleged conversations with the decedent. So 2 people who he talked to 2 years after the conversation with the decedent, only one of them, a lawyer, is on the list, not his brother, just the lawyer. And so every time we bring this up, you know, they say, well, we couldn't have known about it. We just found out. Okay, fine. But when we try to get discovery from them, from the plaintiff, she says, oh, sorry, the discovery period, you can't get any more discovery. For example, we filed discovery requests to get information from the Orlando Garcia law, from Orlando F. Garcia, the law offices of Ramon Garcia and Robert Smith, and they filed a motion to quash. And they said it was untimely because it wasn't filed 30 days before the end of the period, and emphasized that the request should have been served by November 20th, 2019. So every time we try to get more discovery, they throw up walls and say, no, you can't have it. And so to say that good cause exists to let them have this additional deposition and this additional witness is allowing them to also use the scheduling order when they want to the effect that they want it to have. There's no scheduling order. There is a scheduling order. It needs to be made clear. And Your Honor, if you're going to allow the additional late witness, we would request that you reopen the discovery deadline in general so that we can conduct discovery as needed based on the testimony that is elicited from all of these new witnesses that I'm sure will continue to be discovered. We have the issue regarding Mr. Hoblet's testimony being completely irrelevant and does not tie to any personal knowledge of what the decedent told Mr. Sugarick. Their position is that, oh, he's corroborating what Mr. Sugarick said and why he waited so long. Well, the problem with that is that Mr. Hoblet is a lawyer. Okay, the jury's going to hear from a lawyer, that somebody contacted him and said, I have some potential information regarding an estate dispute. I'm nervous about, or I don't know whether I should get involved. Can you tell me what I should do? Can you advise me on what I should do? What would you do? I don't know. I was going to say whatever, something along those lines, right? And because he has not offered his brother as a witness, maybe he will do that too, I don't know. But he's offering his lawyer, Mr. Hoblet, his friend, who happens to be a lawyer, as the witness to say, oh yeah, he called me 2 years later and asked me whether he should get involved, and I told him yes. This is basically an unfair attempt to prejudice the executor with the testimony of a lawyer on why it was important for him to get involved. And he, as a lay witness, cannot offer a personal opinion or legal conclusion. And that's exactly what they're trying to get from him before the jury, that a lawyer, having talked to Mr. Sugarick, said, oh yes, you need to get involved. You need to contact their lawyer and tell them exactly what you know, because it's important, because it has a legal opinion, a legal value to the estate. And so, or to the estate case. And so, Your Honor, we have argued that Mr. Hoblet's testimony is also going to be hearsay, aside from having no personal knowledge about the original conversation. They say, well, he can corroborate that Mr. Sugarick contacted him 2 years later, and why he decided to wait until 2 years to get involved. Well, so could his brother. His brother has not been offered, only Mr. Hoblet. And they're going to say, well, he corroborates and it's not hearsay. And even if it is hearsay, you have to wait till trial before you can bring that argument up. A witness has to have personal knowledge. The only personal knowledge this lawyer has is that he was contacted by Mr. Sugarick and asked what he should do in this situation. He has no personal knowledge about the underlying conversation between decedent and Mr. Sugarick. He was not there. He only knows what Mr. Sugarick told him. The conversation between Mr. Sugarick and the decedent, possibly there is an exception of the dead man's rule that it would apply. I don't know. I haven't heard what the testimony would be necessarily offered, but there is no exception to a conversation between Mr. Sugarick, the decedent, which is then relayed by Mr. Sugarick to Mr. Hoblet. Mr. Hoblet can only testify about what Mr. Sugarick told him happened in the conversation between himself and the decedent. That is hearsay. Mr. Sugarick is not a party to this case. There is nothing that he can do to offer this court and to the jury ultimately that would be equivalent to standing there at the foot of the bed or at the rail of the bed when this conversation allegedly happened between Mr. Sugarick and the decedent. Now, the argument is, well, we're not harmed because there's so much time. We don't even have a trial date. And that's exactly right. We do not have a trial date. There is no new trial date to calculate new deadlines from. This court has not ordered all deadlines to be reopened. It only allowed specific depositions. And so all of those deadlines still remain in place. And I have a case cite for you, Your Honor, Sprague versus Sprague. Let me get the case cite. It is out of the Houston 14th District Court, or 14th Court of Appeals, number 14-08-00700-CV.
And give me the number again. I was waiting for a Southwest side, but
I'm sorry.
just go ahead and give me the
number 14-08-00700-CV.
And you're citing there for the proposition again?
Yes, Your Honor, I'm getting to that part. I'm sorry. I had to move my page to get the site. Oh, sorry. I'm sorry, Judge, I lost my spot. Hold on.
You were citing that case, I think having to do with whether the deadline can be extended.
Yes, Your Honor, and I apologize. I'm just lost my place in the document itself, and I'm trying to find it. Let's see.
Okay, you said you lost your thoughts. So I was trying to help you a little bit, but
Oh, no, I said page, but that's fine. So this case says that in this case, a motion for continuance was filed, but a date was not set. A motion for continuance to the trial date, and the date was not set. And the court said, even though the trial court continued the case, the court made clear that the deadlines in the docket control order remained in place. Under these facts, we conclude that the continuance did not reset the dates in the court order. And therefore the expert report was not allowed to be supplemented. So I don't know if the court, when we're going to have a jury trial in this case. I understand that COVID restrictions are, a problem for, litigants, not necessarily for the public health. That makes good sense. But if the court is going to allow depositions to occur, we would just ask that the discovery period be reopened so that we can conduct discovery as needed without having to come back and ask for leave every time we need it. That's all, Your Honor.
But Mr. Garcia, I'll hear your argument, but let me ask, what is your response to the request that it be opened specifically, and then go on with the rest? Your microphone's off.
Judge, let me start by saying my throat is shot. I have a very bad head cold, so I've been coughing. That's why I turn my microphone off if I cough, excuse me. Judge, if we're gonna cut to the chase on that, the plaintiff does not have an objection to opening up wholesale the discovery. We don't. I mean, honestly, if we had it that way from the beginning, we would have been okay with that. But that's not necessarily the way it had been treated. Every time I designated a witness following the February setting of 2020, that witness was objected to as late. So I understand.
My instinct is to resist it. Because I kind of want to hold the line, but the reason I'm asking is because this COVID thing is kind of a thing that's thrown it out of whack, and my hesitancy is you're just gonna start a whole new series of discovery efforts that might just double the cost of the case. And if I hold a line on the deadline, you'll have to come up with some basis for justifying an expansion. Ms. Gomez, I'm always sensitive to someone that says, well, you treated them one way and you didn't treat us the same way. When we tried to get additional testimony, and I don't remember all the details, but I think it had to do with your unique discovery attempt, which was written depositions by written questions, which seem especially burdensome on non-parties and unusual in that it wasn't like a record request. I don't remember all the details, but it's not apples and oranges. And it was way beyond the authorized dates for depositions by written question. So I remember having the difficulty in the
Judge, you cut off for a second.
fairly present your case. So
You cut off. I couldn't hear you for a minute there, and I apologize. But I did not mean to insinuate that you have been that there has been a disparity in the application of the law by the court. What I was talking about specifically was Mr. Garcia's use of a motion to quash and citing the discovery deadline as a reason why, versus versus now saying that the discovery period shouldn't matter because we're way outside any time periods because there's no trial deadline. That's what I was referring to, and I did not mean to insinuate that Your Honor has any kind of disposition one way or another, or has been unfair. And if that was the insinuation that was left, I do apologize.
Okay, apology accepted. Maybe I was being oversensitive. Mr. Garcia, I'm sorry, I wanted to clear up a couple of things. Go ahead, I'll hear you now.
Okay, so let me move backwards a little bit. The first, I think, let me touch first on the issue of the discovery period, and then clarify a little bit about what you just talked about, Judge. Is that the discovery period had closed in December in anticipation of the February trial, which got reset to April, and then got reset to we don't know.
That was right. That's the January where everything went to hell, right?
Yeah.
Between December and February, that's where, okay.
But yes, and then March comes, April, we're in lockdown. So following the February, following the initial discovery deadline, I designated witnesses after the discovery period who had come to me and approached me after the discovery period. It's true, they did approach me, and I made that clear in previous motions. We went to a hearing on that in person, and Your Honor allowed for depositions of those late witnesses to allow them and to testify, to see what they had to say. Following that, the depositions were scheduled of all except Kathy Shigrick, still pending. And then the defendant, Mr. Rod, sent out an additional discovery on top of what the court had allowed. My point in saying that is that my motions to quash were as to the discovery that the court didn't make clear it had allowed. And I think that's what you were touching on, Judge. So those witnesses were deposed. But my real point for me in saying that is that when those resettings occurred, at that time, I had not looked at whether or not the law of this jurisdiction that we're in today, which is, I believe, the Court of Appeals in San Antonio, whether the law of this jurisdiction treats a resetting such that all previous deadlines are frozen. Because I think Ms. Torres just explained it, the 14th Court of Appeals treats it a different way. My understanding is there is a diversion in the way it's treated. She cites Sprague versus Sprague. Now, I will say that Sprague versus Sprague says that the court made clear upon the resetting that the discovery period was closed. I don't think that happened in this case, so I think it's still distinguishable. Nonetheless, there is Texas Court of Appeals San Antonio precedent, specifically Killam Ranch Properties Ltd. versus Webb County. That's number 04-08-00105-CV that holds that resetting of a trial only nullifies previous deadlines in the order unless the court orders otherwise, basically. So in this case, at the time when we're arguing the motions to quash, I didn't have that information. All I had was that defendant Rod had been holding that the December close of discovery was hard and fast. You can't send anything after that. We had already allowed some depositions to go through. They had sent some additional depositions on written questions to me personally, to the law office that I work for, and to my father, who works as an attorney here as well, seeking our communications with certain witnesses. that was not what the court had ordered. So I went back and just threw their argument against them. Nonetheless, we're here today. The law is still as relevant now as it was then, even though I didn't have the Killam Ranch Properties case then. The Court of Appeals in San Antonio does hold and treat that resettings nullify prior dates unless the court says no. Unless the court says, no, you guys are frozen. And so I'm saying, well, you know, we're here now, we're kind of suspended in animation in that we don't have a trial date, but the deposition of one of the other, we'll call them late designated witnesses, because for lack of a better way to say it, one of the other witnesses that were designated after the December date, because of their deposition testimony, I have other names that get popped up. And then with respect to the relevance, the import of those individuals, specifically the person we're here for today, Clay Hoblit, his testimony is not bolstering. It's not meant to say that Mr. Sugarette is a very truthful person, that he is somebody to be trusted. I cite a case in my response, Judge, that there is a difference between bolstering and corroboration. That case basically says that it's Mumfreeze versus State. And it says that evidence that corroborates another story's witness, another story's testimony, or enhances inferences to be drawn therefrom, in the sense that it is incrementally further, in the sense that it has an incrementally further tendency to establish a fact of consequence, should not be considered bolstering. So I'm not trying to say that Mr. Sugar is truthful. His testimony, the Clay Hoblit's testimony, is solely for the purposes of saying, if Mr. Sugar takes a stand and says, yes, I heard this from the decedent, this is the statement, and let's assume we borrow from Mrs. Torres and it's the dead man's rule that gets that in. I think that there's other ways to get it. I don't think the dead man's rule will get it in, but maybe it will. And let's say it comes in, it's then in evidence. But if he is attacked, as I anticipate that he may be, as he kind of was during the deposition about, well, why come forth in the 11th hour of this case with this testimony? Well, the reason is because he didn't feel comfortable getting involved in a state's litigation. And he was daunted by what he should do. And he sought the help of his friend who happens to be a lawyer. He didn't seek his advice as a counselor, as an attorney. He sought his advice as a friend who is a lawyer. And the guy told him, I think that if I were you, I would come forth. So his testimony is relevant to explain, if necessary, the gap between between him being told the statement and between him coming forth with the information, right? If that becomes an issue. If it's not, then his testimony may not be needed, to be quite frank. But to make that, unless we're going to stipulate here today that Mr. Sugarette can just testify to what he claims that he heard from the decedent without being cross-examined on certain things, that I don't think that they're going to forgo those cross-examination points. Well, then I believe that that his testimony about showing up late and why should be able to be corroborated by Mr. Hoblit. And Mr. Hoblit, I think Mrs. Torres is assuming that Mr. Hoblet's going to testify to the underlying statement from the decedent. That's not really necessary from him. All that will happen is that he can testify as to his personal knowledge of the of what he was told from his friend, Mr. Sugarek. And it will only be the relevance of that will only be to explain the gap in Mr. Sugarek coming forth in this case, to explain that to the jury, because I assume that's going to be a question left unanswered by a cross-examination. So that's the import of his testimony for the purposes of our case. The underlying statement in and of itself is extremely important to our case. So my efforts here to advocate in protection of that, in protection of the veracity of that, I think is well-founded. I think it serves justice. I think that the jury should be able to hear these different viewpoints. And if Mr. Hoblet does start to offer some sort of legal conclusion, which I promise you that was not my intent. I'm not that Machiavelli. I'm not that. I don't think that way. At least not yet as a lawyer. But if that were to happen, then I'm sure Mrs. Torres would want to object and cabin his testimony to something more appropriate from a lay witness. So I agree that we should allow some discovery for Mr. Hoblet. As for why I didn't designate his brother, I don't have an explanation. I could, maybe I will. Mr. Hoblet was the one that came to mind because I had a conversation with him because he was going to represent Kathy Sugarek, and we were trying to schedule her deposition. So I told him that I was probably going to designate him as a witness because his name had come up in the deposition, and he said, "I understand." And so I just didn't designate the brother. I think the specter of him providing testimony that goes outside the scope of what he can provide, I think could be protected by objection or a rule in limine. But I think that to serve justice, we should have these people come forward and at least tell what they know about this case, because it's important for the purposes of the estate and our claims.
Garcia, do you have a cite for the Mumphrey case that distinguishes
Yes, I do.
corporation from bolstering?
It is 155 Southwest 3rd, 651. It's at page 656.
Anything else you want to say, Mr. Garcia?
Well, Judge, I mean, as to the 193.6 argument that if it's not on time, it's late, and if it's late, you got to show no surprise or prejudice. There's no trial by ambush because there's no trial. Now, I think if I say no discovery either, then maybe, then we are working to ambush Mr. Rod. But I agree to do some discovery. Even Rule 193.6C gives the court the authority to continue the case, to allow for the discovery. In this case, we don't need to continue the case. Well, again, we're in suspended animation here. So the court surely has the discretion under 193.6C to allow for the discovery as it sees fit. I think that the court's prior emphasis on the idea that these cases should be about what is heard, not as what is concealed. I think that this serves that principle. And so I think that I certainly won't object to any discovery, Judge. I mean, I just won't.
I was focusing on the good cause aspect in light of Ms. Torres' statement that, and I'm not sure said that these witnesses seem to come up whenever the impression I got is that whenever they checkmate you on a legal theory, is that she didn't use the word checkmate, but that every time that you hit a wall on a legal theory is when you would go to another witness. Do you recall the comment?
Oh, no, I did. I
So
was
I'm
comfortable.
not being fair in your exact words, but that was.
That's correct. I think I said whack-a-mole, actually, or that's what
But,
we're thinking. But yeah, no, that's correct, Your Honor. And I mean, I'm happy to emphasize, to talk about that more, but I mean, I'm sure Mr. Garcia heard it.
well, I don't think that's a fair characterization at all. I was comfortable with going to trial before these witnesses came forward. I don't think that I think the implication that I was placed in a corner on the evidence somewhere between December and February. No, we were already ready to go to trial. I got a phone call from Joe Shigerik, and what was I supposed to do? Ignore it?
So what example do you have that where you've seen this?
Sure, Your
I
Honor.
don't understand whack-a-mole, but I mean the legal theory being.
I understand. Yeah, let me elaborate. We deposed the witnesses that were disclosed by Mr. Garcia. The last one was Robert Smith. We deposed him. He testified that he and Samantha. Well, first of all, we deposed the plaintiff, Samantha Smith. She testified she has zero personal knowledge of undue influence or anything happening. That it all came from other people. So then we deposed Robert Smith, one of the people who said that there untoward behavior happening that resulted in the execution of the will. We deposed Robert Smith. Robert Smith says, oh, well, there's an agreement between Samantha and I about this property. And so then after that deposition happens, the new witnesses come up, Mr. Shigerik, Mrs. Shigerik, and Bill Barfield, all to testify that they want this. Well, okay, Bill Barfield and Mr. Shigerik to testify that the decedent wants the property to stay in them would be.
That's not what Bill Barfield testified to.
Well, okay.
I don't have a record of any
I'm
of
not
that.
going into I don't have his record in front of me. I couldn't, if you say that, that's fine. And then
How does that testimony countermand the agreement? I mean,
It doesn't have anything to do with it. As a matter of fact, the agreement, if it exists, I let it into trial.
it is,
I have no problem letting that in, and I won't even rebut it. I will adopt it. I will accept it that my client didn't want the ranch. Her brother, her uncle was very concerned that Mr. Rod, who knew his brother for barely, less than a year, while he was away out of the state working, had somehow managed to get a will from him. So he was like, hey, niece, you're the only one who can bring a lawsuit. You're the next of kin. She didn't want to do it. She did it. She's the only one.
and this goes
how does that countermand that?
to the whole issue. People are all offering testimony about what happened, what the decedent wanted, and they're all very, very interested and have agreements regarding what's going to happen to the property.
Joe Shigerik, there's been no allegation that Joe Shigerik has an agreement with anybody.
Hold on, Mr. Garcia. Hold on, I'll let you respond in a minute. Ms. Torres.
What's going on?
So while I don't think I said we or if I did, I don't remember honestly what I said in my first opening and whether it was hammering down legal conclusions, but every time they have a witness that offers negative testimony to their case in chief, what could be their case, there is a new witness that comes up with something else. And now there's an agreement, according to Mr. Smith and Samantha, and as Mr. Garcia just told the court, that she doesn't even want the ranch. The uncle wants it. And all of these people are conspiring with their testimony, possibly. And we just keep getting more and more witnesses to corroborate this story that Mr. Smith could have possibly wanted to leave it outside of his family. That that could not have been the case. Now, I think that it is important for me anyway to use this point to segue back to the issue at hand, which is 193.6 and Mr. Garcia's own case, the Kylam Ranch case. That case had a new trial date. This case has no new trial date. Therefore, we cannot set new discovery deadlines based on the rules of civil procedure. And in that case, they said this resetting nullified the previous discovery deadlines related to the trial as set forth in the pretrial guideline order and governed by the rules of procedure. In the absence of another pretrial guideline order, discovery deadlines were governed by the new trial date. We have no new trial date in which to reset deadlines, discovery deadlines based on the rules of civil procedure. And that's the difference between our case and the Kylam Ranch case. The next thing that I'd like to just discuss real quick is that the Mumphrey case that he talks about and how it's corroboration and not bolstering. His case, Mumphrey versus State, says bolstering occurs when one party introduces evidence for the purpose of adding credence or weight to earlier unimpeached evidence offered by that same party. More precisely, bolstering is any evidence, the sole purpose of which is to convince the fact finder that a particular witness or source of evidence is worthy of credit. That's exactly what he just said he wants Mr. Hoblet to do, is to be able to say, this is why he waited so long. And then when he consulted with me, his lawyer friend, I advised him that he should be involved in this estate dispute.
I just argued this. I just said his testimony may not be relevant unless he's cross-examined and impeached. So, and also.
Well, I focused on your comment that has not been, when there has been no earlier impeachment.
Mhm.
So does that depend on the circumstances?
I would.
In other words, if no one has impeached the witness, then it is bolstering. But if you have impeached the witness.
Well, also there's an inherent difference between bolstering, and the case talks about it. I think, you have to read it to understand, but there is an inherent difference between bolstering and corroboration. And so what Mrs. Torres is concerned about is that, if I only use Mr. Hoblet to testify as to why he waited so long, to come forward. And he testifies to that beforehand, and he's not impeached on it, then I don't think Mr. Hoblet's testimony will be needed. But if he is impeached on it, and they raise the specter of, well, you're just doing this because you have an agreement like Mrs. Samantha has with her uncle about giving the ranch over to him if she gets it, which there's nothing wrong with that. But if they argue that he has an agreement like the uncle does, there's a problem with that for certain. And so in order to rebut that, and I don't even think it's really it's still not bolstering. I think it's explaining a delay. It's okay. It's explaining the delay. It's not saying, hey, he waited this long because, whatever. It's just that he came to me and he said he was not sure about what to do with some information that he had about the case. He said he was afraid to come forward. He asked for what I would do, and I told him. Now that will explain if it is that, his delay is attributed to some other malfeasance or improper agreement, which there's no evidence of. And then he's certainly, his testimony will be necessary.
Only till I read that case. Apparently there seems to be some important distinctions there. Ms. Torres, do you want to finish your
yes, Your Honor.
I'll give you an opportunity to respond to my inquiry about where the stuff about each set of new witnesses is as a result of you counteracting or countervailing or
Well,
countering.
I think I've already, I think I responded to that sufficiently. I mean, basically what I was getting at is that every time we depose one of their witnesses that has some unfavorable testimony to their case, a new witness turns up to have some new angle that would get past that. You know, Sam couldn't testify about any personal knowledge regarding undue influence or
She doesn't
fraud.
have any.
Exactly. She has no personal
She
knowledge.
never did.
So then we go to, well, that's not what her her petition says. And so then we go
The
to,
allegations that I made in there as an attorney,
so I am talking to the court right now. I'd appreciate not to be interrupted. And so then we testify, we get the other witnesses on depositions, and Mr. Smith testifies that he has this side agreement that could then show bias and motive into what's going on with his testimony. And a new witness turns up, Mr. Sugarrick, to say, no, now I had this conversation 2 years ago with the decedent, and he told me he wanted it to stay in the family. So now we have another witness saying, independent of Mr. Smith, his brother, saying another family member who says, no, I have personal knowledge, and you can't do anything about it because now I have this knowledge, and you don't get to get any additional testimony.
Amanda, I have your client recorded pressuring him to put something in writing immediately while he was in the hospital on a bed dying.
I'm not a witness, and I am talking.
He was sedated on the day. I don't need any of this, but it helps.
Jury, Mr. Garcia, I'm responding to the judge. Okay?
I know, but you're mischaracterizing this case. I don't think it's fair, and I'm objecting to what you're saying.
Okay.
I'm just going to insert my objection.
Simply
Judge
trying
is
to
over.
respond to the judge, and you obviously will be able to make your case to the jury at the time whenever we get there, and hopefully it'll be soon. But nevertheless, a simple, I don't think Mr. Hoblet has anything good to offer, period. I don't think he should be a new witness. But if the court is going to allow new witnesses to be added, then I would like the court to allow discovery to reopen, maybe at least to the new witnesses that come up either by the defense or the plaintiff's side, so that we can then just move forward without having to come back every time and seek leave to do that. But I don't know, Your Honor, it's up to you. I understand you've already issued some rulings. I would like to get an understanding with the court and Mr. Garcia that, dependent on your ruling today, we may need more time to depose Mr. Hoblet. We only have 30.
I don't have a
Ms.
problem.
Torres, let me, and this was set off because of your statement that assertion that new witnesses are coming up because you have checkmated legal theories before. And both sides will have a chance, but I'm going to ask you first, Ms. Torres, to respond. The original set of 3 witnesses that Mr. Garcia was allowed to designate were based on a finding of good cause and no surprise, because I was going to give you this opportunity to depose him.
Yes, Your
My
Honor.
recollection of the good cause was that this was in response to a designation of witnesses on the last day of your ability to designate witnesses that were a surprise to him. Is my recollection accurate, or do you dispute that, or I want to hear from both of you?
Honestly don't remember, Your Honor. I can pull up the motion, but I honestly could not tell you. I don't remember how or why those witnesses came up at the last minute.
I think what Your Honor's talking about is I had filed a motion to compel at that time, seeking to compel discovery from the defendant to properly respond to requests for disclosures, to designate the names of these individuals that he had in text messages that he had possession of throughout the course of the litigation, long before I ever had possession of the text messages. So they had listed persons with knowledge of relevant facts, and they only listed about 10 people that was favorable to their case. But that's not the standard for responding to requests for disclosures. They had information about other people that had been communicating with the decedent about his estate, what he wanted to do with the ranch. And so I had argued,
Mr. Garcia, did they designate those on the last day of the date that,
no, they didn't. They never did. They
Your
never,
Honor, the Bill Barfield was a friend of the decedent. Joe Sugarick is his cousin, I think, and Kathy Sugarick is his wife. And his what Mr. Garcia is telling the court is that we hid them from the RFD list, the request for disclosures list of witnesses, because they had unfavorable information regarding the case. Bill Barfield was not present at the time the case was filed, and I don't believe he ever visited the decedent in the hospital. Joe Sugarick, text messages were provided to the plaintiff, and he was also his deposition testimony is that he had this conversation, but it was not present in the text messages. We could not have known that he had a conversation about the will from the text messages. That's all we know. We only have what's in the text messages. We can't read between the lines or make up testimony that's not there. The Exhibit A he cites in his response as a text message between the decedent and Mr. Sugarick, essentially saying that there is an agreement or that they did discuss this. All it says is the decedent texts with Mr. Sugarick says, I have a lot I would like to talk over with you, and it is too much for one text. And I really don't want to talk to you about all of this in front of Katie the other day. None of her concerns. So if I could text you a little at a time, would that be okay? None of that it would give me the impression that there's a secret conversation they had about what he wanted to do with his rent. And why would I put that on an RFD list? I put all the people I knew, or we put all the people we knew had relevant information at the time. So for him to say that we knew that they had relevant information about the events underlying this lawsuit is not true. Bill Barfield was his friend, never saw him in the hospital. Joe Sugarick, we only had text messages. It doesn't say anything about a conversation regarding the will or the estate. So that is just a flat out mischaracterization. And I just want to make sure that the court understands that it did not happen that way.
Mr. Garcia, or have you already known your recollection of, I'm obviously misremembering this. I thought I viewed the ruling as being fair because you had been surprised on the very last day and needed to have these witnesses made available to testify because you had just been made aware of them.
no.
My memory
no,
could be.
It wasn't as a result of witnesses designated on the last day, Judge. That's not what happened. It was a result, from what I believe, because Mr. Sugarick was mentioned in some handwritten notes that were not disclosed until expert designations. Then there's a text message that they had.
Hey, that's it there.
It was a text message from the decedent's phone that I didn't have until, way later in the case, that talks about wanting to have a conversation with Joe outside the presence of Kathy. Kathy's one of their witnesses.
But it was disclosed in a latter disclosure having to do with expert designations.
Yes, that's what I know what you're talking about now, Judge. You're talking about that there were some handwritten notes that were not disclosed until expert designations. Yes, I remember that. I forgot about that. Yeah. And Joe was on one of the handwritten notes. That's right. Because their expert witness whom we had deposed relied upon those notes as a basis for his opinions. And so those notes didn't come forth. They're arguing that I didn't ask for them. And nonetheless, I didn't receive them until expert designations. And so Joe's name was became, I guess, more of an issue in this case when expert designations came. And that prompted, I guess.
Okay, I'm gonna look at the two cases that have to do with the deadline, and I'm gonna look at the case, the Mumphrey case, as far as Moultrie. The last thing I want to cover, Mr. Garcia, for purposes of good cause, what record do I have that would, from the motion I saw, you have the burden of establishing good cause that must be shown in the record.
Again, Judge, I will I will, well, the purpose of good cause, that it would be that the deposition was taken after the discovery was closed. So we deposed Joe Shigerick when only by virtue of the fact that the court allowed us to. When we deposed him, he mentioned Clay Hoblet. I didn't have Clay Hoblet's information when I spoke to Joe over the phone. When he called me, he only told me about the conversation he had with his relative in the hospital, and that there were text messages to back that up. So because the name came about due to in the late designated witness's deposition, then that witness, of course, is naturally also late. So the good cause is just that one flowed from the other, Judge. One flowed from the other, and so they were both late. But again, there is no surprise. If we can
Good
depose
cause,
Mr. Hoblet.
R, no surprise. Is it R, disjunctive in the rule?
I think
It is an or.
that's a good question, Judge.
It's an
And I
or.
think it's one that's not.
It's an or.
Okay,
It is an or.
okay. This is your motion, Ms. Torres. Well,
Yeah.
before I let you have the final word, Mr. Garcia, is there anything else you want to add? I'll tell you that I'm going to read those two cases and make my decision, but I want to have Ms. Torres have the final word because it's her motion.
Just other than the fact, Judge, that this witness came about through Joe Shigerick's deposition, which was already late, and his testimony may or may not be relevant depending on, I think, the course of trial. So his testimony may not be needed, but it would, if it is, it's extremely important. And I do not, plaintiff does not object to discovery. So if it is allowed that he be allowed as a witness, then we do not object to any discovery. And other than that, Judge, I have nothing more for the court on the motion.
Ms. Torres, I'm going to have your final word, but your distinction on the case, the San Antonio case, has
Your Honor, you're breaking up.
San Antonio being that the case was actually set for trial, had a new setting.
Yes, Your Honor. In the Kylam case, there was a new trial date in which the parties could work from to get their new deadline.
Which brings in either the court ordered schedule or the schedule in the rules of civil procedure.
Correct, Your Honor.
Okay.
So I
Anyway,
don't.
your last word on the motion.
Sure. Yes, thank you, Your Honor. I really don't have much else to say. I just would ask that I just do not believe that they've met a good cause showing. I don't believe that the deadlines are nullified based on even their own case, the Kylam case. And I also believe that Mr. Hoblet's testimony is completely, he completely lacks personal knowledge about the underlying conversation. His employment as a lawyer is also problematic and likely to confuse the jury based on him being a lawyer and saying, yes, you should come to, you should offer what you have. I just don't think that he should be allowed to testify as a witness. Deposition testimony does not show impeachment. And so there's no need to have him to extend the deadlines in this case, to add new witnesses. We should be done with this and just waiting for a trial date. That's all, Your Honor.
Ms. Torres, my order denying your request that he be precluded from representing. I'm not familiar with any case that creates any kind of conflict in the context of representing a witness.
No, Your Honor.
I'm familiar with the lawyer representing the party and the conflicts that are derived from that, but so based
was-
on the record and evidence that I had, that I've
Yeah, I
never seen or heard of that.
I was referring to him not as Kathy's lawyer being confusing to the jury, but as a lawyer, you go to a lawyer and you say, I have information, what should I do with it? And the lawyer says, you should get involved, or you should tell somebody, or you should go do whatever. It's different than if your neighbor tells you you should call somebody, because a lawyer has more of a weight and credibility behind them in terms of their understanding of the law and the effects of that possible testimony. That's what I'm referring to, not necessarily Kathy as Kathy's relationship, as legal relationship with Mr. Hoblet.
So does your view hasn't changed on offering to just open it up?
Well, I mean, I agree with the court, I don't want to have this thing mushroom into a huge, we're pulling tons and tons of people in. I mean, but if the court is going to allow a new late designated witnesses in the now or in the future, I just think we should just be able to go get discovery from them. And if we have to get it from third parties because of that, then I guess we can come back to the court for that. But I'm just trying to reduce the amount of times we have to come back to the court for permission to do something. So I would be amenable to any conclusion, any result the court wants to do in terms of opening the deadline period, whether it's a limited opening or just general. I don't want it to mushroom like the court said. I think we should be done and just be waiting on a trial date. But if we're going to keep adding witnesses, then I just would like to be able to go get discovery instead of having to come back and be delayed in that process.
Well, the February setting, jury trial setting fell right at the point where this COVID thing took off. And we did reset it for 2 or 3 months. In that context, I guess everyone thought this thing was going to be over in 2 or 3 months.
Yeah.
And that just hasn't been the case. And by the way, you asserted that it was reset 2 or 3 months down the road. I didn't remember that, but
I did.
How does that factor into the San Antonio case, that it was actually reset?
I said it was reset.
I thought you had.
I'm not aware of that. I know that the court canceled the trial date and there has been no new trial date. I don't recall. Let me word search my.
I misunderstood. I thought you said it was reset to May or March or something.
That's what Mr. Garcia said, that it's been reset, but there's no actual date. In his motion to, in his response, that's what I believe he said, but I just want to do a quick word search on my pleading to make sure it doesn't come up in my pleading that I said that in my pleading. It comes up in his motion, in his response to our motion.
Oh, okay. With regard to that issue, Mr. Garcia, I don't want to leave you without a chance to respond.
No, I didn't. After the April setting, I never stated or pled that it was reset. I've always said that we've just been waiting.
I thought April setting, so I thought the original jury trial setting was February.
Yes, and then it was reset to April.
Okay,
That's correct, Your Honor. And in my
so how does that April reset come into play on the San Antonio case?
The April reset, the date was canceled and no new trial date has been provided. So we don't have any deadlines to work from. So I would say that it's the same result. There's no new trial date for these discovery deadlines.
Now, I will add that this is kind of an unprecedented situation. That's all I'm going to say as well, is because you're never going to be in a situation where unless it's just due to malaise of the lawyers, you don't get a new date. But, we're here without a date only because there's a global pandemic. And I'll just say that. But I don't think that the San Antonio Court of Appeals based their reasoning on the new trial date, which, in any other normal universe of our, reality, we would be